Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.
HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard.
All right, thank you so much for making time to join us. My name is Kobina Ansong, and I'll be your moderator for today's session. It's a pleasure to be here once again to connect with you all. Kindly confirm if you can hear my voice. If you can hear my voice, just say yes, I can hear, and let's take it from there. Oh, there are some questions coming in already. Whoa, please calm down, calm down. All right, so let's confirm if you can hear me. Please confirm if you can hear me. It's loud and clear. Thank you so much, Isaac Ba. Today's session is going to be in two folds. So we are going to have a 30 minutes discussion with my guest. Then we will do an additional 30 minutes with whoever is watching us. And we want you to share all your comments in the comment section. If you have any question you want us to address to, we want you to share in the comment section, and our guest will be here to answer everything for you. So great to be here. We can hear you. Thank you so much, Rejoice. Thank you so much, Rejoice. Loud and clear. All right, now I can proceed. So today's discussion is on labor laws of Ghana. And to do this with me, we've been always doing this in conjunction with two great men. I call them great men because it's so easy to get a great man like that. You get it. So I'm happy to always get them. Help me welcome Kofi Edinkra and Stephen Kisi. So these are the two people we use here. Hi, Stephen.
Hi, Kwabna.
Stephen, can you hear me?
Yes, Kwabna, I can hear you. Can you hear me?
Good. I can hear you. This is our first time, so let me take this opportunity to wish you Afishiapa.
I think of it,
for you speak Chi, I can say Afishiapa.
I think of it,
I don't know about Mr. Kofi. They also speak.
He's a chief professor.
Hi, Kofi, can you hear me, Afishiapa? Okay, I think Kofi is trying to join us back. So, by the way, Stephen, how has your week been? How's your weekend been? And any updates we need to know from you? And hi, Kofi, can you hear me? Hello, Kofi, can you hear me?
Yes, I can hear you now.
Good. Kofi, I wanted to find out, do you also speak Chi? How do you say Afishiapa in your language? Kofi, your network is okay. All right, so let's proceed with Stephen. Stephen, can you hear me? Can you confirm if you can hear me?
Yes, Kwabna, I can hear you.
All right, Stephen, thank you so much for joining us. We want to take this time to thank everyone who made it to this discussion. I can see some questions coming in already, and we will tackle everything. So this is how our session is going to be. It's going to be in two folds. We'll have a 30-minute discussion. Then we want you to also share all your questions, everything bothering you with regards to labor laws of Ghana. Feel free to share in the comment section. Stephen is here, Kofi is here to address that. So let's jump straight into our discussion today. Let me start with Kofi, if you can hear me, Kofi. Kofi, is there any updates we need to know about the labor laws of Ghana before we move on into our questions? Is there any updates we need to know about the labor laws of Ghana?
The labor laws are currently undergoing some changes, and so there's at the end of last year, some work was ongoing to reform the Labor Act. Things are not, I mean, it's not complete yet, but we can expect that in the near future, there will be some changes to our current labor laws.
All right, thank you so much. Stephen.
Stephen,
let's have that conversation. Stephen, is there any updates you think we also need to know from the labor? You have worked with the Labor Commission for almost 10 years. I think it is the same thing. Do you think there's any updates we need to know from your side?
Well, I think that what is in the immediate now, aside what the very respected Mr. Dinkra just spoke about, is that conversations have started towards the minimum wage for 2025. Okay. I think they started the conversations last week. So hopefully, before the budget is read in March, hopefully we can get a new minimum wage to work with for public sector workers. So that's one update I can quickly share.
So Stephen, let me continue. Talking about minimum wage, let me start with what are the basic rights that an employee under the Ghana law enjoys? What are the basic rights? I'm an employee. What are my basic rights? Before we come, I know wages are there, but what are my basic rights?
Okay, so if you look at if you pick our labor law under section 8, an employee enjoys under section 10, an employee enjoys certain basic rights.
Okay.
So one of those basic rights would include receiving information that is relevant to the work that you do, which sometimes can be a cause of a lot of dispute when the why we have employed you is not so clear. It can be a basis for which you would find the worker and the employer being in some form of dispute. Okay. And then also there's the bit that talks about the fact that you have the right to either form or join a trade union. You have that right. You have the right to receive equal pay for equal work. That really means that you should get paid for the work that you do, without recourse to other issues such as your gender, your race. And because Kwabna and Kofi know each other, so when I employ you, I will pay you more. But when I bring Ajua in, I don't really know Ajua, so Ajua there, I will pay her less. No. So when we say equal pay for equal work, that's what we are speaking about. Fairness in terms of compensation. So those are some of the basic rights that a worker enjoys under the Labor Act, specifically under Section 10.
So thank you so much, Stephen. Let me ask Kofi this follow-up question. Kofi, how do these rights protect employees in different sectors?
Okay, that's quite simple. They level the playing field in the sense that in the general employer-employee relationship, the employer tends to wield more power. I mean, they are the one who are the employer can make or break you.
Okay.
So what these rules do, or what these provisions that Stephen has referred to, their purpose is to, because they provide a structure which regulates the relationship. It's just like a football match. So if you have, and I know some of the football fans may come after me, they may come for me, but for example, if you take a football match between Real Madrid and Tano Bofwaka, for example, imagine a match like that without a referee, without assistant referees, without VAR. You understand? You see that it's not going to be the same as if you have a structured match. So that's the purpose of these laws, of these provisions, so that whether you are the weaker one or not, and it's not always the employer, mind you. Some employees are also very powerful, such that they can also abuse their relationship. So that's the purpose of these rules, to create a level playing field for everyone in the employment relationship.
Kofi, when playing football between the team you mentioned and the local team, okay, I'm a football fan. I also don't want to mention any football name for people to come and chase after me. It's mostly between 90 hours or 90 minutes or 60 minutes. I want to find out, if you are to contract someone to work for you, how many hours, okay, am I expected to work for you?
Okay. So generally we know 8 hours, right? That is you're working for 8 hours in the daytime. But again, if it's a matter of law, a matter of the relationship that is established by the Labor Act or our labor laws, what is important is that the worker does not work continuously for more than 40 hours a week.
Okay.
And also, so you can arrange it however you want to arrange it, as long as it makes sense. But it shouldn't exceed 40 hours a week. And the employee is supposed to have at least about 2 days rest after working continuously for a week. Let's put it that way. But generally, it's 8 hours. So you may find that, and I know someone may be wondering, you may find that some people work, especially those that go to work at night, or those that work in certain establishments, manufacturing establishments and the rest, that they have 10-hour shifts, which is more than 8 hours, and the rest. Or some may go in the evening, they may come back the next morning. It's because you shouldn't work cumulatively for more than the 40 hours a week. And so you find that typically in some of these establishments, when the worker, if you go for, let's say, 12-hour shift, sometimes the following day you don't come to work, or the following day you report at 2 p.m. if you closed, late. It's so that cumulatively you don't exceed 40 hours a week, and so that you can also have a rest period every day. So the rest periods are 2, every day and then every week. So at least you should have, you can't work 24 hours. You cannot work 24 hours unless perhaps you're an essential service or you work in the security services for whom the general provision, the Labor Act does not apply to. I'm sure we all know that. We all know that by now. But generally speaking, it's 8 hours, subject to the exceptions that I have mentioned.
Okay, so if it is 8 hours and I'm told to do 10 hours, that means there should be a bonus, or they should compensate me for that 2 hours. If I get it right.
Okay. So if you are doing 10 hours,
okay.
Yes and no. So if you are doing 10 hours and cumulatively you are doing 36 hours in the week, then you are not entitled to any compensation in quotes or any bonus. However, if the shifts that you do or the shift you are required to engage in exceed the cumulative for a week, which is the 40 hours a week that we have just mentioned, then you may be going into issues of overtime.
Okay.
And for overtime, you are required to be compensated. Your employer is supposed to compensate you for overtime.
I see. Stephen, we are talking about bonus. Before bonus, some employees and the employers can decide to have an agreement where they will say that I'm not going on leave for 3 days, for 1 week. I want you to pay me. So I'm not going on leave for the whole year. I want you to pay me. I want to find out what does the law say about it?
About not wanting to go on leave for the whole year?
Like, yes.
So for the best part, Mr. Dinkra taught me a few things. So
Okay.
And he's still my teacher. Once
Yes.
he's my teacher yesterday, he's my teacher forever. So he will tell you that what have the two of us agreed on in terms of the contractual relationship.
Okay.
So you would find that in the world of work, besides the employment contract, there's the condition of service.
Okay.
Now, all of those things are still subject to our labor law. And the labor law says that in any given year, you should enjoy a minimum of 15 working days as leave.
15 working days?
Yes, 15 working days. Yes, 15. Not
okay.
50. 15.
Okay,
now,
so before you continue, the 15 working days, does it include weekends?
No. In an establishment, so we're talking about, so it depends on your status in the organization.
Okay.
So you will find that if, let's say, you are a shift worker, your working days may differ from somebody who is a straight day worker.
Yeah.
So a straight day worker will do Monday to Friday and rest Saturday and Sunday.
Okay.
A shift worker would do cumulatively Monday, Tuesday, Wednesday, and rest maybe Thursday, Friday, and then resume work Saturday, Sunday, plus another Monday. You get the difference now. So let's just say we are talking about the average Monday to Friday worker. So the law is saying you have 15 working days minimum as leave. Okay. And the same law is saying that you cannot have an agreement to forego leave. So even when we contract that this relationship, you cannot go on leave, it will be alien to the provision in the law. That is why whatever it is, no matter the nature of work that you do, those minimum 15 working days there, your employer should give you those days to rest so that you can reset as a human being. Let's say that's the time you can do your servicing. If you were a car, you would go maybe 3 months. Mr. Edrika drives a finer car, so his servicing goes maybe like 6 months. He's a big man. But when you do the normal Kia Picanto, Toyota Corolla, like some of us, then you have to be doing your 3-month regular servicing. So for an employee, those 15 days are literally what we'll consider to be your servicing period, where you take time off work, you relax a little, you come up with new ideas whilst you are in the house, so that when you join again, you are fresh as if you just joined. Yes. So that's why the leave requirement is important.
Stephen, leave is actually good. It's good for
It
your
is.
mental health. You need to rest. Even Jesus Christ rested on the seventh day. So as human beings, we need to. But let me ask. I want to sell my leave to the company I'm working with, and they are saying no. So they want to terminate my appointment. Okay. They want to terminate my appointment. They want me to come on leave, like no leave, because they need me to be there. They want me to terminate my appointment. Can my employer fire me without giving me a notice?
Okay, so if you look at how the labor law has been framed, ideally you cannot be terminated without notice.
Okay.
So the notice, and Mr. Dinkra is here. When I get it wrong, I'm not worried. He will correct me. So the notice stands on two legs. There is the part where we are giving you some advanced knowledge of the fact that we intend to terminate, or we give you money so we don't have to give you the advance notice. So those are the two legs that it stands on. So if you look at section 17, there is some breakdown of how notice is supposed to work. So it will tell you that generally, if the relationship is 3 years or more, you are either paying 1 month's salary in place of notice, or you are telling the employee that today is 15th February. Yesterday, those who went out in the evening, we saw all of you. So today, 15th February, in 1 month time, which would be the 14th or let's say the 15th of March, our relationship is no more. So that's when the law, you have given advance notice. But sometimes if I look at the role you perform in my organization, if I leave you to stay for 1 month, you may cause me a certain damage before you finally exit.
Okay.
So take your salary that you would have earned in the next 1 month, take that so that you don't have to stay for 1 whole month again. Then once I'm paying you that salary in lieu of the notice, then ideally I have satisfied it. That's why I say that if you look at how the labor law has structured notice, you cannot suffer termination without being given the proper notice.
Kofi, let me ask, what constitutes wrongful dismissal under Ghana law?
Yeah. I'm sorry, Kwabena, can you repeat the question? I didn't hear it.
To find out what constitutes wrongful dismissal in Ghana, when in terms of the Labor Act of Ghana, what constitutes wrongful termination?
Okay, so and Stephen, I know Steve will smile when I say this. You have used two words that tend to mean two different things.
Okay.
So you've asked about what wrongful dismissal is and what wrongful termination is. So for practitioners, dismissal and termination tend to mean two different things. So before I attack the piece of the question, let me just address the two terms. So termination is a general term for bringing the employment relationship to an end.
Okay.
Dismissal is a way of terminating. But that term is generally reserved for terminating your employment because of some disciplinary issue. So where your employer is of the opinion, is of the view that you have misconducted yourself. I'm using misconduct as loosely as possible. Or, so you've gone through proceedings, maybe appeared before a committee of inquiry, or you are deemed to have committed an act that is so serious that on the spot, that is known as summary dismissal. So dismissal is a way of terminating your contract. But usually when I hear dismissal, I think of some wrong that the employee has done. And so wrongful dismissal would be where you have dismissed an employee using an unfair process or a wrong process. So, for example, generally we adhere to the principles of a fair hearing, so that if an employee is deemed to have done something wrong, you usually, practically, you begin by giving the person a query or asking the person to show cause or to justify their actions, which means you are hearing from them. If you are being asked to justify your action, then the next thing is to wait to get that explanation from the employee. And then you subject it to whatever rigor you want to subject it to. You evaluate it and decide, okay, your justification makes sense, and so we end it there, or it does not make sense, and so we are taking disciplinary procedures, disciplinary steps against you, which may include dismissal. Where you don't give the employee the chance to give their side of the issue, and then you dismiss them, for example, that's an easy and clear example of wrongful dismissal. Now, mind you, let me state that there are some offenses that you can be summarily dismissed for, which means they are not holding an inquiry. There is no committee of inquiry. They are not calling to appear before DC. So that is where what you have committed is so grievous, and perhaps it was committed in the plain view of everybody. Then that's one, as they will say, common sense will say that as for this one, you don't even need to go through formal proceedings. That's one thing. But for other offenses where maybe there are some allegations against you, that's different from seeing you do something or you doing something straight away. But where some allegations have been made against you, then we need to investigate. So if we don't go through the process properly of investigating and hearing your side, then we may talk about wrongful dismissal. But wrongful termination in itself, that's the broad term of termination. Termination can be wrongful either because of the labor law or by the conditions of employment. So here, let me chip in that the Labor Act or our labor laws provide a minimum standard. Your specific conditions of service at your workplace may go beyond the minimum standards that have been set by the labor laws of Ghana, by the laws of Ghana. And so if we are going by the standard, your employment relationship is governed generally by the labor law, then if your employment is terminated in a manner that goes against the minimum standards that have been provided by the general labor laws of Ghana, then we can talk about wrongful termination. But on the other hand, if your conditions of employment are better than what is in the labor laws, and that is what both parties have signed as your contract of employment, and they do not follow the procedure in your conditions of service, you cannot go back and say, well, we didn't follow the conditions in the contract of service, but it still conforms to the Labor Act, so we have rightfully terminated you. No. So for example, if the labor laws require notice, and if your employment is an employment from month to month, then you are entitled to 1 month's notice. But your employment may be from month to month, but your conditions of service say we should give you 3 months notice. Your conditions of service will apply, will take precedence over the Labor Act because it is better. If your conditions of service said we can only give you 1 day's notice, even though you are an employee from month to month, then that is worse than the labor law, so that one will not apply. But when it is better and they do not give you the 3 months notice, that is also wrongful termination. In simple terms, that's what I would say about it.
Thank you so much, Kofi. This webinar is brought to you by the HR Certification Center. And at the center here, we provide professional certification for HR practitioners. And one of our certification program is Senior Professional in Human Resource International. And this one, the requirement is you need a degree and a master's degree to be precise, and you need to have a 4 years experience. We have both online and in-person option. It's a Saturday and a Sunday. So for Saturday, it is from 9 a.m. to 3 p.m., which is you have to come to our office here at East Legon for the session. And if it's online is from 1 o'clock to 6 p.m. Right after church, you jump online to learn everything you want to do. I want to inform you that everything we are discussing here is actually part of the modules we are going to take you through. So the modules that we are going to take you through the Senior Professional in Human Resources International, we have Leadership and Strategy, Workforce Planning and Talent Acquisition, Employee Development, Total Rewards, Employee Relations and Risk Management. Then Module 6 is the Labor Laws of Ghana. So if you have a master's degree with 4 years experience, we recommend this professional certification for you. If you also have a bachelor degree in any field with 2 years working experience, we recommend the Professional in Human Resources International for you. And that one too, you go through a 6-module period. And within that module, 6 module, we have module 6 to be the labor laws of Ghana. It's the same thing. We have physical option and we have in-person option. Then if you just left university, you have a degree or you don't have a degree, you have no work experience, we recommend the Associate Professional in Human Resources for you. And that one is 4 months duration. And with that one, you go through the same 6 modules. You go through 6 modules. And that one is online only. And the online starts from 1 p.m. to 6 p.m. You don't need a degree, you don't need a work experience. So therefore, our team is waiting for you. Just send us a WhatsApp message. Send us a WhatsApp message on 0244 122 855. 0244 122 855 on WhatsApp, and the team will be there to assist you. We've done almost 30 minutes and we want to take your questions. So before we take your questions, let me take this question first. Let me ask Steven. Steven, if you can hear me, can you take me through what is workman compensation? What exactly is workman compensation?
Okay.
Steven, can you hear me?
Yeah, I can hear you, Kwabena. Okay. So workman's compensation, I think that just as the term says, is compensation that is due a workman. And the reason is that you have suffered an injury or an accident whilst conducting your employer's business or an activity that is considered to be in the course of your job. So from where you sit in your office, I know you have a very nice office. The frames at the behind you I can tell. So let's say you're probably picking, it could be anything, maybe a laptop or something from one end to maybe downstairs or the floor on top of yours, and you slip and fall and you get injured. You were doing something in the course of work, so then we would say that you would qualify for workman's compensation. Or maybe you've been sent on an official errand and then, touch wood, you suffer an accident, you get some injuries, then you would qualify for workman's compensation. So it is largely money you earn. Let me bring it down to our everyday English. It is money you earn when you get injured or suffer an accident whilst doing your employer's job. That's literally what workman's compensation is. But there's a bit of a cue here. It is not all of the things that you do that you may get compensated for. I'm sure that maybe sometime during our conversation, those ones may come up. And when they come up, we'll look at how we can address it. But let's all understand that generally, when we say workman's compensation, we're saying that it is money you get for any form of injury that you suffer or an accident you suffer whilst carrying out your duties as an employer. But the one quick information though, the new labor law should, I think earlier Kofi mentioned that some work has been done on, amending our current labor law. So when they finally gets before Parliament, it is now going to be known as the workers' compensation, not workman's compensation. They say for gender reasons, we are now making it general. It becomes a gender neutral term. So it will now be worker compensation. Thank you, Kwabena.
Okay. So let's start taking your questions. So if you have any question, we have approximately 20 minutes. So we are dedicating the rest of this session for your questions. Feel free to type your questions there and we'll answer it. So this question came in before we started the interaction. So this is the first question. Paternity leave. It reads, since paternity leave is not explicitly recognized in the Labor Act but it's included in the Public Service Commissions HR manual with a provision of 5 days. Can a public service organization choose not to grant this leave to its employee? Salary deductions for absenteeism. Is it legally permissible for an organization to deduct money from an employee's salary as a penalty for absenteeism, even when the employee has available leave days? Kofi?
Yes. Thank you. And as some people will say online, thank you for the question. And so the question seems to be divided into two: salary deductions, that's disciplinary measures, and then paternity leave. I'll just refer us to something I said earlier, which is that the laws that we have in Ghana, which are applicable to workers, provide a minimum standard. And so if you are working in an organization or in a sector which has enhanced conditions of service, those conditions of service are what would apply. Apart from that, we also have the contract of employment. So typically what happens is that your employment letter does not state all the conditions of your employment. What it may do is that it may give you the general terms and then it will refer to a manual, maybe the workplace manual or whatever conditions of service exist. They have different names. They have different names. In one of the organizations that I am affiliated to, it is called a quality manual. In other places, it's just conditions of service for public workers, whatever that it is. As if there's any particular document that applies to you regarding your category, the type of worker that you are, you're entitled to it. And so if speaking about paternity leave, what I would suggest is that you check. A lot of us, after we get our employment letters, we don't check again. We just start working. I would suggest that you check your conditions of service. Even if it is not found inside there specifically, but your conditions of service refer, or from your conditions of service, you are covered by the Public Service Commission's HR manual, for example, then it means that you're entitled to that benefit. And so if it is not granted to you and you have a legitimate ground for trying to access that leave, you can always take steps to claim that benefit. And so if it's not given to you, then you may want to take the steps to claim it or to enforce that right that you have. That's on the one hand. Now, the issue of salary deductions for absenteeism. So this there's something that Stevens people like to say, which is that an employee's salary is sacrosanct. Yes, depending on where you mention this, people will disagree with you or not. But generally, when it comes to somebody's salary, it is not something that that is supposed to be attacked or tampered with on a whim. And so usually what you would expect is for full proceedings to be taken. If because that would be a disciplinary issue, right? So you may most likely be queried. You will give your response. A determination or an evaluation will be made on your response. If it's an issue of committee of inquiry or appearing before a DC, a disciplinary committee, you may appear, give your reasons before a decision will be taken. But professionally, I would say that straight away, docking your salary, especially when it is not part of the conditions of service from the beginning, that can be a problem.
Yes, I'm here. Kofi, can you hear me? Steven, let me ask this question. There's another question from here, from Roberta Northy. So Roberta is asking, when engaging casual or temporary workers, must 6 months renewal continue? And until when would you make them permanent workers?
Okay, so for the most part, what I tell people is that casual work is seasonal in nature, and that's why there's that segregation or there's that arrangement. You are either a casual worker, we bring you in on a temporary basis, and then or a fixed term, whatever the situation is. Now you would find that largely when somebody is a casual worker, usually the work that they are employed to do is one that's at best 2 weeks, 3 weeks, up to a month and a half. They are done, they go away. But a temporary worker would probably spend 3 months or more with you. Maybe the person is replacing someone who has gone on maternity leave or somebody who has taken steady leave, and you still need that role to be active within the establishment. So those differences are there. Now, when the person has spent 6 months and you intend to renew or continue with the relationship, then it means that from the 6 months and onwards, you would begin to treat the person like you would treat your permanent workers. The person does not become a permanent worker. But if let's say your permanent workers get transport allowance, they get medical cover, they get provident fund, all of those arrangements, then this temporary or casual worker should begin to enjoy these things. So that even though they are not in the proper sense a full-time employee, i.e. a permanent worker, they are enjoying all of the perks that a permanent worker enjoys because they have stayed beyond 6 months. Now, it is for the most part, I tell people that if you know that the relationship you are going into, you are going to spend more than 6 months with the person, I'd rather suggest that you give a 1-year contract. So it does, you save yourself the hassle of trying to decide after 6 months, do I start paying you this and giving you that and giving you that? Once you are bringing the person, you know how long you want the person to stay. So if it is going to be more than 6 months, just do what will make you rest well or sleep like a baby, and just give a 1-year fixed term contract. Then within that period, you can assess and determine if after the expiration of 1 year, you would want a more permanent relationship, or you may want to continue on a fixed term contractual basis. Otherwise, you will find yourself, Mr. Dinkra, how do they even put it? You'll be swinging from on one day you are on the left side, in 2-3 days you are on the right side, and you keep going this way. When trouble comes, that is when you know that you probably might have done yourself some good if you had stayed on a straight path and not be going between two sides of the coin. So that's what I would say. You don't become a permanent worker after 6 months. You get treated as a permanent worker if the relationship is casual or temporal in nature.
So but there's this question on a ball of kinky. Let me ask. The person is the person is, why is the minimum wage so minimal to the extent that it can't even buy 2 balls of kinky with fish? The first thing is you need to find out how much is a ball of kinky. Now
I think on the average is like
you
5
need to
CDs.
5
5
CDs.
CDs.
I
Yes.
said it. Good.
Yeah.
Great. So what is the minimum? The person asks, why is it that the minimum wage is so minimal that it can't even buy 2 balls? With this one, I leave it to both of you. Why?
Well, I think that the current minimum wage, senior, I think is 18 CDs, 18 pesos or something. So that ideally can buy you
18, 15. 18
yes,
CDs, 15 pesos.
that can buy you 2 balls of kenke. And if the kenke seller is merciful, you may get some few, those small fishes for 5 CDs so
Yeah.
that you can get a decent meal. But as to why it is so minimal, having grown like that, and Mr. Dinkra equally is also not so grown like that. But this one there, this cap, I will pass to Mr. Dinkra.
Hey. I mean,
Okay.
I'm
realizing.
I think this is something that it depends on where you are standing. So somebody will say that it's so that every employer every employer has their strength, and so the minimum wage is pegged such that it's supposed to serve as a balance between employers paying something that is fair and employees also receiving something that is fair. The rest, I would honestly say that it's a matter of economics, exchange rates and all those things, which we cannot discuss here. But one thing I'm sure that we can all agree on is that generally wages in Ghana are low. I would say that generally wages in Ghana are low. But the reasons we cannot, unfortunately, we are not, it's not something we can decipher here.
Kofi, let me follow up. Now you are done with eating your kinky. Then you want to resign. Can an employer decide not to accept the resignation letter of an employee? And what are the legal bearings does it have? That's the next question from, is it Peniel?
Yes, Peniel. This is a very interesting question. And I like the question because it gives us a chance to give some particular education. So first, resignation is a notice. In actual terms, it's a notice. So what you are doing is that you are giving notice to the, so in this case, this would be notice to the employer that you are bringing the employment relationship to an end. It is not an application for permission to fall out, if I should put it that way. It's notice. So for notice, you do not need anyone's permission to resign. If you want to resign, you are free to resign as long as you are following the conditions of employment. So that if the notice period is 1 week, 30 days, whatever that it is, you are following up. However, there's a twist. So what some employees do is that when disciplinary proceedings have started against them, then they try to escape that by resigning. In such situations, your employer cannot physically hold you or arrest you. However, those disciplinary proceedings may affect your entitlements, so that you may give notice of your resignation, maybe at the end of this notice period, you are bringing the relationship to an end. But if certain disciplinary proceedings have already started against you at the time that you gave the notice, those proceedings can still go ahead and come to a conclusion. At the end of the conclusion, if, for example, there's going to be some penalties against you, or they are going to deduct some things from you, you are supposed to pay back some money to your employer or anything of the sort, then they may take it out of your entitlement, your end of service and entitlements. So whilst resignation is a notice of termination, these are some of the things that we should be aware of. I don't know if Stephen will want to add something to this for me.
Well, I think that Mr. Dinkra has actually said it all. You would find that, like the example he gave, people are quick to think, oh, once some action has been instituted against me, let's say like a disciplinary action, like he mentioned, I can just serve notice of resigning and then that would be it. But you can trust that even in your absence, your employer can actually proceed with the disciplinary activity, and then the sanction will be communicated to you that, well, following your decision to leave, these things also proceeded, and this is the final decision of the committee, and then whatever consequence you are supposed to suffer, they will communicate that to you as well.
Stephen, this question is to you. It said, Mr. Kisi, please can a response to an audit observation be a basis for a disciplinary measure if the employee admits he or she had committed an offense?
Well, if the employee in responding to an audit observation admits that, yeah, maybe I was negligent, or I probably may not have been diligent in my duty, hence X, Y, or Z, then based on that admission, then the employer can now proceed and carry out some disciplinary measure if the employer elects to do so. Or somebody will say, because you have confessed, then will pardon you but probably go away with a warning of a sort. So yes, once you admit to it, then really you make it easy for a decision to be made. It's like you get caught for stealing and you are sent to the police station. They present you in court. Your statement you give to the police and the one you mentioned to the court is that, oh yes, I did it, I stole it. We don't have to now go beyond why you stole, were you hungry? No, those are the arguments that will probably make to see if the judge can lessen your sanction a little. But once you have admitted, then we don't have to go through all of that stress. Then we can actually go on. So yes, the employer can proceed to do that.
So we have 9 minutes, and trust me, we have a lot of questions here. We promise to answer it all, but we have 9 minutes. Let's just run through quick. There's a question from Eunice Owusu. Okay. Can an employee commence work by verbal mutual agreement without an offer letter? Kofi, please, can you tackle it for us?
Yeah. The simple answer is yes. But what I would say is that as immediately after commencing the agreement, she must be given, or he must be given that that letter, that employment letter. Very simple.
Okay.
I mean, the actual situation is that you should start the relationship with a letter, but practically, some things happen. A new business, a business that started operations today, for example, they may be going through some administrative processes. So practically speaking, there's nothing wrong with starting, but immediately, as soon as possible, you should get that letter so that you can know where you stand.
So there's this question. Let me put this question to both of you.
We are not here. Steven, are we here?
Please, we are not here.
So,
George,
we don't belong to any political party.
George, we have seen your question. Kwabena, don't worry, we have seen the question. What is the position of the law? I think that you will find that the commentary now is that if you disagree, you should test it within the corridors of the court to see what the position of the law is. As for what our personal and professional opinions are on this matter, let's just say this place is by the roadside. I don't know about Mr. Indikra, but for me, this is by the roadside. We can have a one-on-one discussion.
I'm by the roadside too.
Okay, so the two of us are by the roadside on that particular question. But George, you can trust that we are willing to engage outside of this as much as we can. But for this particular event, pardon us. Okay.
Thank you so much, Stephen, for that. Let's ask Kofi, there's this question from Roberta. She's asking, I have an employee who has been absent from work since last year, September, without any formal notice. As the HR, I have reached out to him several times and I want as fast as query him.
As far as query
for
him.
3 times, yeah, as far as querying him. For 3 times, stop his salary, yet still he is not coming to work. His excuse is that he has hernia. Okay. His excuse is that he has hernia and that it is spiritual. So he is at a prayer camp. Please, how do I handle such an employee within the labor law?
Okay, that's another interesting situation that we have. And let me say as a preliminary comment that our Constitution guarantees freedom to practice your religion. But I always take the opportunity to say that freedoms that are granted to us as citizens are not absolute. And whilst person A has been granted a freedom, person B also has a freedom. And so coming to this specific situation, this if you are this should come under sick leave. And any form of leave should be applied for, or where it is an emergency situation, because you cannot always apply for sick leave. If you are coming to work and then you collapse, there's no opportunity to apply ahead of time. But as soon as practicable, you should be able to notify your employer. And so in this situation, September is how many months ago? The question is, what is a reasonable time to have received formal notice from an employee of their sickness and requirements to be on leave? So what is reasonable is usually on a case-to-case basis. But we all generally understand that some things are reasonable, some are not. If you are undergoing hernia treatment, for example, of course, I am not a doctor, but I can imagine that it will not stop you from contacting your employer. And in this case, the employer has reached out. If I heard the question properly, the employer has reached out through the HR, and even disciplinary procedures have been taken against the person. I imagine that even though the salary deductions have been made, they have, after that punishment, they have been restored. It seems to me that the salary has been restored. And so in this case, the employee stands the risk of being held as having abandoned their post if they have not provided any response. So where you have not abandoned your post, then you are required, where you have abandoned your post, your employer is no longer required to treat you as an employee. So that is when they may decide to, terminate your treat. In fact, abandonment of post means you, the employee, has terminated your employment. And so the employer is within their rights to, terminate that employment. And so if, on the other hand, the employee had applied for leave, provided a medical report or whatever that it is, then they could have been on sick leave by now. Yes, please, what's the follow-up?
Yes, so Eunice is asking, are sick leave excluded from the actual number of leave days communicated? That is the 15
yes,
days.
So the 15, yes, the minimum of 15 days is annual leave. That's different from sick leave or compassionate leave. So annual leave is 15 days. It does not include holidays. It does not include non-working days. And it also does not include sick leave. So for sick leave, practically speaking, you can be on sick leave for as long as you need. However, where you've gone through the proper procedure, you've notified your employer, you've provided a medical report or whatever that it is, you can be on sick leave for 3 months on your full pay. 6 months, that's from the 3rd month to the 6th month, on half of your pay. And then subsequent to that, the employer may not pay you at all. And then further, they may terminate your employment. But that because you are no longer fit, you may be deemed no longer fit to work for the employer. On the other hand, they can decide to keep you, to wait for you to be well and come back if you are that valuable to the organization, but they may not be paying you anymore after 6 to 9 months. So that is how, but yes, so to answer simply, sick leave is not part of annual leave.
Okay, so let's take this last question. We want to thank you all for asking your questions, but let's take this one, then maybe we can call it a day. From Enoch Saki. Enoch is saying that I work in a company that has 3 categories of employees. 1, permanent. 2, contract. 3, outsource. All contract staff are subject to renewal or renewable after 1 year per your date of joining. This is a company that has been operating for over 30 years. Do you think this contract renewal is a good practice? Because there are few of these contracts that have worked for more than 5 years, but are still not permanent staff. Still under contract. What does the law say about this? So I will take your view on it, Stephen. 1 minute, 30 seconds, and I will take 30 seconds from Kofi.
Sorry. So in 30 seconds, now having all of those categories of workers in an employment or by an employer is not wrong. Our laws actually allow that you can have these kind of things present in your workplace. You would find that under the 3, permanent, contract, and outsourced, a lot of the time the liability the employer will owe for these 3 categories would differ. You would say that for permanent and contractual staff, they may owe similar liabilities to those staff. But for the outsourced staff, that becomes a contract for service. So they may not owe certain liabilities as they would owe to permanent and those under contract. That's what I can say in 30 seconds.
All right, Kofi.
Yes, Stephen has said it all, but in addition to that, with regard to the duties that the employer owes, so you realize that for the outsourced workers, they are managed by their employer. So their employer is a different entity who has stationed them at this employer's place of work. And so their SNIT, for example, and other statutory payments are handled by their employer, the one who sends them. The contract workers, they are, as Stephen said earlier, they are entitled to be treated as permanent workers, although they are not permanent workers. So just that their contract runs for a year. And then the permanent workers are those that we say they have tenure, security of tenure. So it is very much allowed for these two workers. So you realize that the contract workers, the employer takes care of everything, including their statutory deductions and the rest. And then for the contract workers, it's not like that. They handle some, and then the employer also handles some. then they outsource they outsource workers. It is their actual employer that handles all of that. So that's what I would say about that. It's fine. It's not illegal.
All right. Thank you so much, Kofi. And you see, it's been an insightful discussion. All too soon, this is where time will permit us to end the session. But before we end the session, Stephen,
yes, Kwabena.
Any closing remarks? Any closing remarks you want to share?
I think that, well, like you said from the beginning, it is the making more ample time would help, so that we can explore more, because there are times I feel the 1 hour that we set for ourselves is not enough. And so maybe we can look at maybe our next session. We can look at maybe an hour and a half, if it is possible, and if Mr. Edinkra and myself are available for 1 hour and 30 minutes. But another way to help all of those who joined us would probably be by, if you ask me, I would say pick a course with the HR Certification Center. You would find that by the time you conclude all of your 6 modules, you would have had all of these questions answered and more. The 1 hour, 1.5 hours, yes, we will try our best, but it probably may not be enough. So this one, free advert for the center, I would say that's one big advice I can give. Or the other bit of it is that you can also go and see Mr. Edinkra. He's a lawyer. You pay some fees, and then he can also give you proper legal advice. If you come to me too, I'll collect some fees, and then we can advise you. But if it comes to improving your knowledge on this HR spectrum that we find ourselves within, then I'd say that, look, your best bet is with signing up with the HR Certification Center, and then you make life easy for yourself, and then for Mr. Dinkra and myself too.
All right, Mr. Dinkra, last comment.
Yes. I agree with Stephen. Of course, we can always find time and have a longer session to try and deal with more of the issues. Again, I would also repeat that the best is to also sign up for one of the courses, depending on your level of qualification, with the HR Center. And of course, we are always available to also consult on maybe some pressing issues that anybody may have. But above all, for all of us that are in employment, always read our conditions of employment. It is easy to get into the routine of doing your daily tasks and getting used to how to do it. But as time goes on, you may forget some things, or you may find convenient ways of doing things, which may, or even your employer may do the same, which may not be in accordance with the laws or your conditions of service. And so always keep abreast with your conditions of service, and you will always be safe. Thank you very much.
Thank you to Kofi, and thank you, Stephen. It's been an insightful discussion. As Stephen said, if you want the full pack, we want to encourage you to join the HR Certification Center. If you're an HR practitioner, yes, you can call us on 0244 122 855. 0244 822. Sorry, 0244 122 855. And to let you all know, this webinar is always on our social media channels. It is on YouTube, it is on LinkedIn, it's on Facebook. If you have anything, if you are facing anything, you can just go back and watch for clarification. On that note, we want to thank you all for joining. And as always, I'm your moderator, Samuel Kwabena Anson. Thank you all for joining, and see you in our next session, which will come on very, very soon. So please keep safe and enjoy your evening. Thank you, Kofi. Thank you, Stephen.
do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.